So this will be the content for today, whatever we are going to discussion, what will be the part of discussion today. So starting with what is privacy, then what is the importance of privacy and compliance in today's corporate world, why companies are just going mad behind privacy and all those stuff. And the reasons behind those will be the next 3 points which you see, like GDPR, CCPA and LGPD. So these are the some comprehensive privacy regulations which have been released recently, and which has created like a storm into a corporate world to get into compliance and all those stuff. So we'll have a look at that. Then we'll come across what's the importance and roles of privacy professional, what are the future perspective and future opportunities in terms of privacy field and information privacy. Then how an organization can achieve those privacy compliance, and we'll come on to the question and answer sessions at the end. So in this section, mainly what you are going to understand is how privacy impacts to an organization, why organization needs privacy compliance, what all privacy compliance are mainly impacting organizational operations in today's world, how privacy operationals will fit into the requirement and how they can look forward in a future career perspective, and how they can help their corporate to achieve that compliance. So let's start. The very buzzword in today's world is privacy. So what is privacy? So I have come across this term from Dr. Anne Kavonian. He is a data privacy officer for Canadian government, and he was the guy who has built privacy by design. That's a concept in information privacy field. So he has given a very good statement about privacy, which says like privacy forms the basis of our freedom. You have to have moments of reserve, reflection, intimacy, solitude. So privacy is anything which is private to me and I want to keep it to myself. In case if I want to disclose it, so I want to disclose it to a predefined individuals, predefined organization, and it should be as per my view and as per my control. Like if I want to share my details with so and so person, then I should be totally in control of that information. Suppose if I say something to my colleague that okay, so X thing has happened, so that thing should stay with that colleague itself. So if that colleague needs to disclose that to someone else, he should inform me or he should take consent from me, and then that can be disclosed to a third person. In that way, I'll be in total control of that particular information. So in nutshell, privacy is important in everyone's life, and in today's world, privacy has very broader terms when we compare it in a regulatory terms and all those stuff like GDPR. So we'll go through some of the definitions as well. And what is information privacy? So information privacy is the right to have some control over how your personal information is collected and processed. So suppose if I am going and purchasing some item from Flipkart or Amazon, I am providing them my detail, my home address, my phone number, my email address. So I totally believe that Flipkart and Amazon will be keeping it safe, and Amazon and Flipkart should implement all the possible ways that they are making sure that my data is safe with them. So this is a very buzzword in today's world: privacy, privacy, privacy. So, and the evolvement of this regulations, privacy regulations, has made it very much important for each and every corporate to ensure and to keep the data of an individual very important to them. So processing information privacy, when it is in terms of organization, it has a very broader scope. Like in today's world, every organization holds data from each and everyone. So what does this regulations bring in? Why it is so much impacting in today's organizational world and corporate world? The reason being, any regulations have defined data in such a way that any operations you perform on any data comes under data processing. So data processing has a very huge scope in today's regulatory environment. So any kind of operation you perform, regardless its collection, its use, its transfer, its storage, deletion, encryption, decryption, any kind of even read, write, any kind of operation performed on data or a personal data of an individual, that comes under processing. And when any operation or anything is performed, the regulations comes into picture. So in nutshell, anything private to me is a private information. So we'll see in detail what is considered as private. We have seen like what is privacy. Anything private to me is a privacy, which I don't want to get it disclosed to each and everyone. I want it to be disclosed to certain individual. Now, what is personal information and personal data? So in order to protect something, you need to know that what you are protecting and what you have in order to protect that. Okay, so definition of personal information is very broad and covers almost anything and everything that can identify an individual directly or indirectly, and that includes each and every sector. Like today we'll be focusing mainly on GDPR regulation, what it says about privacy, what it says about personal information. So in GDPR, definition of personal information is very broad and very huge. It covers everything right from physical identification, psychological identification, genetical, economical, cultural, social, each and everything, whatever a human can think of, in whatever ways a human can be identified. All those things are covered under GDPR. It is so huge and so broad, and that has made each and every organization to focus on that, and the level of enforcement GDPR brings with it is adds to the flavor. So what are the examples of personal information? So if you see, there are two types of information. One is direct information and one is indirect information. If I would like to explain you what is direct information. Direct information is anything which is directly related to me, or through which an individual can directly identify an other individual. Suppose X and Y, there are two persons. So, and in an environment, if there are only two persons, and if someone calls about X, then definitely people knows that he is the person who is being referred to. So the direct information consists of name. It's not limited to this. There are huge number of examples of direct information. To quote some of them are like name. Through name, you can easily identify an individual. A bank account number. Through that bank, each bank account number is unique with each and every individual. Car registration number. Car is always registered on an individual's name. So if you have the car registration number, that is considered as personal information. Then you have social identification numbers. So this includes, if you talk about India, it includes Aadhaar card, PAN card, and if you talk about US, it includes social security number. So in that sense, whatever identification number we have, so through that an individual can be directly identified. Now there is other part of personal information which is called indirect information, like date of birth. Now through date of birth, you can't identify an individual directly, because same date of birth can be of multiple individuals. Many persons can be born on the same date. So now if I have a date of birth 5/8/1998, so that doesn't relate to any single individual. It can relate to X person, it can relate to Y person. In order to relate to a specific individual, you need some additional data like name of an individual, location of an individual, and date of birth. This gives some kind of exactness or individuality to an individual. So if any information through which you can't directly identify an individual comes under indirect information. We have marital status, like a person can be married, a person can be unmarried, there can be multiple states. So how can you define like this person? If a person is unmarried, we are talking about this person? No, we can't. So it comes under indirect information. Online purchases, age. So definitely if you combine some more information, if you borrow some information from direct information and if you combine it with indirect one, then definitely you can reach out to an individual and you can single him out. So now what GDPR focuses is any information through which an individual can be identified. It can be in n number of forms, as I'll go to previous slide, which shows that it can be physical, psychological, genetical, like DNAs, blood groups, mental health, or economic background of that person, if it is borrowed from a specific bank, or what is the cultural background, what race or what religion he is belonging to. So any information which you can imagine about, all those things are covered in a very huge and broad scope in GDPR. So now, what is the importance of this privacy compliance? Why we need this privacy compliance? The reason being, we corporate has been working since long. So why all of a sudden we need this privacy, and why people are running behind this privacy compliance and all? So in today's world, the technology has grown at a very rapid speed. Every day we hear something new coming up, and today the corporate or the world is totally digitized, I would say, and most of the users are having mobile phones, internet, and this was not the case earlier. And earlier the data used to be in physical form, and it used to in a very isolated, kept in a very isolated manner, and even if something goes wrong, it won't have a huge impact as it would have today. So if a server of a health insurance company is hacked, so that contains very confidential and sensitive information about so many individuals. It right from their health status, their right from their medical background. If data from bank is hacked, so they will have all those kind of account details and all those sensitive personal information. So now the world is very much going towards an environment where everyone needs their own privacy, and it's not that it is very new. It is new in the sense that it has been regularized. Earlier it was not in that form. Earlier there were regulations in, but I would say I'm not sure if the enforcement was not at that level, or the range or the reach of the regulations was not at that level. So many things has added. Why are we giving importance to privacy in today's world? Like if I would like to give you an example of artificial intelligence and IoT and cloud. So these are some of the latest technologies in artificial intelligence. Now most of the companies or most of the businesses are running on AI, where you want to reduce human hour in order to maximize your profit. So what it does is it accumulate data from very n number of areas, and it just runs some algorithms within itself, and then it gives you with some kind of result. Based on that result, organizations are making their service decisions and all those stuff. So this can have an impact to an individual. If I quote an example, like a bank is X bank is there, if they want to process loan for individuals who are applying, so there are chances that now bank might be using some kind of technology through which they will be feeding their last 10 years of bank statement into it, and they might be running some algorithm onto it, and then it gives you a result that he or she is not eligible for particular loan. But that is totally based on automated technology and no human intervention. It can have an adverse impact on an individual whom the loan or a certain service is denied. So in order to protect those individuals from this kind of thing, so GDPR says that there has to be manual intervention in those kind of things, and you can't just give a decision based on certain technology. So there are certain things which GDPR has covered right from technology and everything. So IoT, artificial intelligence, cloud infrastructure has created big challenge for corporates and entire across the globe. The reason being, GDPR is applicable to each and every country who is doing business in Europe, and will come into specifics of it into the later portion. So now if you are storing data outside EEA, like European Economic Area, it is abbreviated as EEA. If you're storing data outside of it, then you have to meet certain compliance or regulatory standards. So, and who all are having access to the cloud infrastructure? What kind of security are you using? So there are lots of clauses and lots of rules and regulations which has been defined around the technology, and the reason the importance of privacy has increased. Also, the reach of today's organization is very huge. Like earlier, it was not used to be as it is today. So data collection has increased, the reach of the organization across the globe has increased. Different technologies has come into place, which has created lots of challenges for an individual to protect their data, as well as for organization to come up with the market and provide that kind of services, along with maintaining compliance and regulatory requirements. So now why this is more important, the three main reasons are why a company want to go with the compliance. The three main reasons are brand name, the reputation, and the consumer trust. We all have been hearing about Marriott data breach. We have been hearing about British Airways data breach. So these are very huge data breaches which have taken place, and in which millions and millions of users have lost their data to the hackers or to unauthorized individuals, which are kept on dark web for sale and all those stuff. So in keeping importance or privacy is mandatory today for any organization in order to succeed in today's world. Why? Because the information today spread more than the speed of the fire in a forest. So if a breach has occurred in a small or smallest of organization, and as people are closely following regulations like GDPR, so that is immediately reported. Like if there are certain portals where even 10 users data is hacked or breached, so that comes under data protection authorities notice, and then they put it on the website that the so and so vendor has been violated. And there are certain clauses in GDPR which says that when service provider or the organization himself or themselves have to inform individuals whose data has been breached. So over here, information is breach information are spreading like fire in the market, and which can create a very bad reputation for an organization, which can impact their brand name, which can give them a loss of business, and many intangible losses which cannot be calculated in terms of numbers, sometimes loss of customers and all. So because of these many reasons, there are lots of importance which is being put on privacy. Now, the biggest and the major importance apart from this thing like brand name, reputation, and consumer trust, the penalty which has been put in by GDPR regulation. So what it says is, if you see, look at the penalties of GDPR, like it will be a nightmare for any organization to come under non-compliance of it. If I say like there are of penalty has been divided into two parts, like minor data breach or minor non-compliance or major data breach. So if there are certain articles and certain clauses in GDPR regulation, if you violate them, then you come under minor. If you violate certain articles and clauses, then you come under major. So the minor data breach will levy the penalty maximum up to 2% of your annual turnover and 10 million euros. So which is very huge. Similarly, in major one, it would be around 4% of annual turnover and 20 million euros. So looking at those kind of penalties, it's very difficult for an individual to even imagine, or for an organization to imagine the kind of impact it will have on its business. And it's apart from brand name, reputation, trust, and loss of business, loss of customer, you have huge penalties. And most of the organization doesn't have that kind of cash in operating and all those stuff. So it becomes very difficult for organizations to keep up with the business if they are not in compliance with this privacy upcoming regulations. So this has created a lot of pressure on organization to be in compliance with privacy laws. Now, what has added through this privacy regulation is the accountability. Now, if you see in GDPR, it specifically speaks about accountability. If an organization is processing data about an individual, and they have collected data about an individual, and they are the controller of it, then definitely they are accountable for it. And if anything goes wrong with that data, then that organization is accountable for it. So here it goes in an organizational or a flow chart kind of thing: data controller, data processor, sub processor. So we'll be discussing those terms into next slide when we'll be discussing about GDPR in specific. So now privacy regulations. So there earlier privacy regulations in place, and there was evolution, and the sudden emergence of privacy regulation and importance of privacy has come into picture. And mainly I would say because of GDPR, which is enforced and applicable since May 2018. So in today's world, each and every company, each and every country in today's world is behind privacy regulation. Every country wants their own privacy regulation, and every country in one or the other form is in the process of drafting their own privacy regulation. Suppose if I give an example, 26 to 27 countries come under European Union, and for them they have prepared GDPR, which is very much enforceable and in implementation since May 2018. See, if you look at US, they have state-wise and sectoral laws, not comprehensive like European Union. They have sectoral laws like HIPAA, they have COPPA, Children's Online Privacy Protection Act, they have FISMA. So they have different sectoral regulations. Now the US states are coming with their own privacy regulations, like CCPA California has come up. Then there are other states like Georgia is in the process, and there are New York is in the process of drafting their own privacy bill. So if a country like US, which has 40 to 50 major states, and if each and every states come up with their own regulations, then it becomes very difficult for organizations to operate. The reason being, we all agree that there are some kind of overlapping in each and every regulation, but being in compliance with 40-50 regulations of a single country, it's very difficult. So now as CCPA was implemented from 1st January 2020, and then it was to be enforced from 1st of July. Now there is an update into it that now they are redefining it as CPRA, California Privacy Regulation Rights Act, or something like that, which is CCPA version 2.0 being told, and it will be coming under November 1, 2020 presidential election ballot. Post that, it will be, there are some modifications which is being made into it, and then it will go into enforcement, I guess 2021, enforced at the end of 2021 or 2022. So that is the plan what they are going through. Now GDPR is already in place. Now there is a latest addition to it is LGPD of Brazil, which is Brazilian Data Protection Law, which came into enforcement, I guess, a week back on 18th or 19th of September. And if you go through the regulation of LGPD, then it's also very huge. It also has 65 articles and all those stuff. So because of sudden emergence of this privacy regulation, there is a lot of importance an organization has to put in place. And how it got evolved, it's not that it's totally new as it came in 2018 with GDPR. If you see like there are some major privacy act or privacy regulations which are in place, and they are in place since long time. Thing is that their enforcement and their reach, what made the difference when GDPR came into place. If you see right from 1948, even earlier to that, there were some minor organizations or NGOs working in Europe and different part of the world who had some kind of regulations or kind of policies, I would say, because it was not regularized to through the national government. So if you see from 1948 Universal Declaration of Human Rights, then ECHR, which and 1980 OECD guidelines. So this European Convention of Human Rights, Universal Declaration of Human Rights, and OECD Guidelines Convention 108, and all this was the basis for Data Protection Directive, which came into 1995. I guess Data Protection Directive of European Union, which is revised as GDPR today, was the first comprehensive one. And because of, and the base was OECD Convention 108 and universal, and all this was based, and it was going on, and in 1995 it came as a comprehensive one in the form of Data Protection Directive. Then HIPAA is another privacy act. No doubt it's specifically related to health individual, and it is only applicable to US citizens. Children's Online Privacy Protection Act, which is again US sectoral law. Then Federal Information Security Management Act, which is, there is the breaking on the biggest of all, 2018 GDPR, which changed the role and the way an organization look at the regulation till date. 2020 came in CCPA, which is again under revision, and they are going under reviews, and they have made some changes and they want to make it more stringent. The penalties have been increased, and there are some major changes which has been made into the law, and it will again come under review in November 2020. And the latest week back which got implemented, which is LGPD, General Law of Personal Data Protection of Brazil. So all the countries are today mainly focused on their own citizens' privacy. One of the reasons I would say is everyone has understood the importance of personal information. So it also belongs like if you see on a global perspective, it's not just that the major goal is to protect an individual of their own country. Countries are running behind the privacy regulation. Apart from that, the national interest and the national security of an nation is also dependent on the personal data of individuals. So it gives very clear and crisp picture to enemy countries or competitors, like what kind of stage this country is in. If certain data are being moved outside of X or Y country, then it can cause damage to that country in some or the other form. And in today's world where things are mostly digitized and there is more importance kept on the privacy information, this all things like privacy regulations which have been coming like a storm from across the globe has, I would say, forced organization to think into this direction, to force even countries even to think like what are we doing about our citizens security, our citizens privacy and our national interest. So for example, like as you all might be aware that Indian Reserve Bank of India and Indian government lately in 2019, there was a lot of news that Visa and MasterCard, two major card brands, are being asked to host their data center within India and not host Indian citizens' data outside data center which are located outside of India. The reason being this can cause a privacy breach, I would say, or it can cause an issue to national security or national interest of India, and no nation wants it. So in that way, people, organization, individuals, and even countries, everyone has started moving in that direction of privacy regulation. And sudden evolution like GDPR, CCPA, and LGPD has only added to the importance of it. Now, we have understood like what is privacy, what are private informations, what kind of private informations an individual has, what can be, how it can impact in an adverse manner if given gone in a wrong hand, or if it is or the other. Why, how important it is for organizations. If you see the privacy regulations penalties, if you talk about GDPR, so GDPR is very comprehensive. The material scope and the territorial scope of GDPR is very huge. Like if I would like to say, there are three major categories in GDPR. If an organization is based out of EU and they are servicing EU, then definitely they comes under GDPR with no doubt. If an organization is not based out, suppose an US organization is doing business in Europe, they are and servicing European citizens, regardless they are charging or they are not charging, they are providing free service, any kind of service provided to European citizen, data collected in return, or any kind of processing which is performed in European Union or outside of Europe comes under GDPR. So GDPR has a very huge scope in terms of material and territorial scope. So, and the importance and the broader scope which GDPR has in place, like it has not left anything which you can imagine. Now, in GDPR, what all things come? Now, if you imagine a personal data can be in any form. Now, direct information about an individual, name, PAN card, Aadhaar card, or SSN number, car registration number, these are direct information. Definitely, those are personal data. Now, GDPR has not even left the digital form. If someone is browsing websites, if you guys might be browsing website today, you might be being asked like, do you want to accept our cookies? This is the cookie policies, this is the cookie policy setting, you have to go and do that. There is, if you go just recall yourself 5 or 10 years back, when, or at least even 5 years back, if you go and recall that, you won't get such kind of pop-ups on your website and so many options. You can deny cookies, you can accept cookies, these are the settings you can do for cookies. So all this thing has come into picture because of GDPR and its scope. Now what they have told, if I want to give you an example how deep they are into, if a user visits a website and cookies are stored onto his or her system, then that means that individual is being tracked, and that comes under their personal data. Because if a user is browsing A or B products, and if that computer is being used by other individual, then definitely that, because of those cookie settings, the other individual who recently came and started browsing on the system will get ads related to previous users browsing information. So now this would give a breach of privacy for first user. So even they have gone till this step. Now they have also mentioned that even IP address is also a privacy, private information. Web cookies and browsing behavior are private information. If you are being tracked through Google Maps or any application which shows you nearby offers, nearby restaurants, they are under GDPR. So any kind of information you imagine, if even if you are in a church and if your CCTV is placed outside it, then even there were issues. If you there were issues in the courts of European Union when this GDPR law came into picture, like there are CCTV cameras in religious places and that is required because of security reasons. So a court has clearly told that you have to inform individuals that this is the camera over here, this is monitoring how long data will be stored and whom you can contact for additional details. So you can place a camera, that's not an issue. And you have to give all the details an individuals require. Similarly, if you go in a mall, there is a mass surveillance. So GDPR is like very huge. It consists of 99 articles spread across 11 chapters, and it initial articles of GDPR speaks about how what GDPR says, like territorial scope, material scope, what is the lawfulness of processing data, how you can collect data, on what basis you can collect data, on what basis you can process a data, then what is the responsibilities of an organization if they collect data directly from an individual, if they collect data through third party, if they collect data public, if they use publicly available data, then data subject access rights, which is a huge or I would say complex activity for any organization in today's world, because I have been working with many of my clients, and the major issue they are facing is they have collected data and they are collecting data, but the major issue behind all this thing comes in when a user requests certain their rights which is provided to them under GDPR. They can ask you what data are you holding about them. They can ask you in a digital form, they can ask you in a written form, and you are obliged, if you are under GDPR scope, then you are obliged to provide them that data. If they want their data to be transferred to third party, you have to have technology in order to transfer that, though it is not mandatory. But GDPR says that if an organization is able to, and they should work towards it. It's not that it has implemented in 2018 and they will start finding each and everyone if they don't have that kind of technology. So you have to, suppose if I want to transfer my data from Airtel to Vodafone, and if it comes under GDPR scope, then Airtel has to transfer my data to Vodafone, and they can't provide any hindrance to me. If they can't, then they have to straight away tell that we don't have any technology and this is the data we are providing to you in so and so form. You can go ahead and forward it. So this kind, if a user wants to ask an organization, okay, that's it, I don't want my data to be processed anymore, as we are getting in India specifically, we are getting lots of marketing offers and spam emails in our mailboxes, and we can do all is to just unsubscribe. But still, if you unsubscribe 10 emails, you're gonna get another 40 emails in your mailbox. So because the reason in India we don't have any such kind of comprehensive laws, but GDPR gives that kind of thing, and which makes organizations activity very challenging and very complex. Now the material scope, the territorial scope, the lawfulness of processing of information, how you should process information when it is collected from an individual, from third party, from public places, or what are the rights of individual, how they can exercise that right. Apart from that, GDPR also speaks about what kind of activities an organization should perform to be in compliance with GDPR, though it doesn't speak anything in specific. Like if I say, they don't say that you have to do this thing in detail, but they give an overview of it. Like they say, you have to perform data protection impact assessment. Any new technologies, if you are using the data in a form which can cause risk to an individual. Now, GDPR hasn't specified list of activities in which you have to do, but it's up to the organization how they want to interpret that kind of regulation. So now we all know that GDPR or any other regulation can have hundreds and thousands of interpretations. So it is always desirable. Organization will always go with the expert of the regulation, like a person who is GDPR expert. Definitely organization will reach out to them. Okay, so GDPR clause number 28 says about you should only use processors who you think can provide all kind of GDPR compliance to you. Now, how it has to be done, that is not mentioned in GDPR, though it gives an overview that you have to have right of audit for your sub processor. You have to look and make sure that that processor has right contract in place with you and all those things, but it doesn't give you the detail what kind of contract you should have, what kind of activities you should perform in order to reach a conclusion that particular contractor will help you or will help in your GDPR compliance. So that is Article 28 of GDPR, which talks about specifically using sub-processors and vendors in general term, if we call. Now, then there is data protection impact assessment. One of the articles speaks about it. if you are using any new technology, like suppose if you have started using any new technology like artificial intelligence to evaluate performance of an employee in a workplace, if you are using certain technology where you will say like bank can provide loan to certain users or not because you are using technologies. Now you have to assess those technologies, what adverse impact can have. Suppose if you are switching from A service provider to B service provider, till now your business was very small, it was in a small room and you were hosting your own data in a single room environment. Now your business is expanded. So and cloud, if you want to use cloud technology, as it provides multiple advantages with cost effectiveness and compliance and security and all those stuff. So how can you do that? So you are shifting technology, you are shifting the way you did business, so that might create a risk in future terms. So in that case, definitely you will have to perform data protection impact assessment, or in general terms if we say risk assessment or risk management. But this data protection impact assessment is very in-depth and it requires individuals to be informed about it. Like if you are using certain technologies and if you have come across that risk, what you have to mitigate those risks, and if the residual risk is high, before going ahead with the technology, you have to inform your data authority or data supervisory authority, data protection authority, supervisory authority. There are a lot of terms in GDPR regulation. So you have to inform them if you are confused, if you should go with the technologies as the residual risk is very high. So how this can be done? So that is one part, DPIA. Now the other part is the requirement which GDPR places of compliance. Like there are multiple ways you have to if data is being transferred out of Europe or European Economic Area. So earlier there were a lot of, I would say there were options like binding corporate rule was one of the thing, standard contractual clauses were there, then model clauses were one of the thing, and apart from that, specifically between US and Europe, as we know that most of the major giants into business and corporate world is from US, and US's organizations has reached across the globe. So they were very much active within Europe as well. So in order to transfer data from Europe to US or anywhere outside of EEA, EEA means European Economic Area, which comprises of 27, 28 countries. After Brexit, I guess it's 26 to 27, UK has went out. So in order to get the data out of those area, you have to have certain process in place which ensures individuals that your data will be protected in the same manner as it was being protected within European Union area. Now, the options were standard contractual clauses, like between a controller and a processor. Controller is an individual, it can be an organization who defines how that data will be used, who is responsible for the collection of data, making decisions on based on the usage of that data is termed as data controller. And data processor is an individual or an entity who will process data based on the guidance provided by the data controller. So Amazon is a cloud service provider. Now, as long as it stores my data, I'm an X organization. If I'm using AWS as my service provider, so AWS will be a data processor and I'll be a data controller because I have collected that data. I'm responsible for that data, and that data is stored in AWS and it is being processed based on my guidance. Like processing, as I told, it covers anything or everything you can imagine about, right from collection till deletion, transfer, storage, reading, writing, encryption, decryption. Any form of operation on any data will be a processing, will be considered under a processing operation. So AWS definitely, it will encrypt data, it will decrypt data, it will transfer data. So definitely they are performing processing operations, but those operations should only be in compliance with my guidance and my contract, what I have told them. If anything beyond that they do, then they will be considered as data controller. So what all liabilities or requirement I have to fulfill, the same thing has to be fulfilled by AWS. So it is huge in that sense as well. Now, so if you want to transfer data from European Union to US, earlier there was specific thing which they implemented, which is called EU-US Privacy Shield. European Union, United States Privacy Shield, that was a framework they used to transfer data. And under that framework, I guess there were 16 to 18 principles. Those 16 to 18 principles were matching with GDPR that ensured that whatever data is being transferred to US, and US government and US organizations are keeping the same kind of importance on data, private data of individual as Europe government and European culture keeps. So US Privacy Shield was one of the formation or one of the process through which data was being transferred. But lately, there is a guy called Schrems, Max Schrems. He is an Austrian citizen. So he is been challenging these things, like he challenged the data in Court of Justice of European Union. So he challenged the data that whatever data is being sent to Europe by Facebook or any other giants like Amazon and Apple. So specifically, he targeted Facebook and its entities like Instagram and all that. They are providing those kind of data to federal agencies of US like CIA and FBI, and who is monitoring European citizens in one or the other way, and which is a breach of privacy for Europe national interest and for individuals as well. So that was declared as non-compliance, and that was removed. So now organizations which were using EU-US Privacy Shield to transfer data from European Union to US can no longer use it. Apart from that, definitely you have different sets of clauses still present, which is model clause, contractual clause, and standard contractual clause, binding corporate rules. So still there are things, but even those have been made a bit complex. Like suppose if I have to give you example of BCR, which is known as binding corporate rule, what it means. I'll just give you an overview to make you better understand how deep this GDPR is. So there is an organization called Amazon. Suppose if I take an example. Now, Amazon has various entities across the globe. Their entities is in Switzerland, their entities is in France, their entities in US, in India, and everywhere. So now the main entity of the Amazon, they have to decide now if Amazon is doing business in Europe, so they will not consider the US entity as main entity if European entity is taking major decision in terms of European business. So suppose Amazon Europe is an entity placed in Europe, which is deciding all the business strategies and making all the business related decisions for Europe, European business and European market. Then yeah, Amazon US will not be the main entity. Main entity will be Amazon Europe. So now that data can be transferred across the globe in various entities for different operations, and the operations of MNC is spread across the globe. So as we are working with US organizations, so we process US data in India. So similarly, European data might be processed somewhere else in the world, wherever Amazon entities are being placed. So as long as the data was between Europe and US, it was under EU-US privacy shield. So now there is no longer EU-US privacy shield. Now if they use BCR, then all the entities across the globe which is affiliated with Amazon has to fulfill the same kind of compliance regulation or the same kind of compliance standard which European entity is following. So that is BCR. Through BCR, you can bind all your entities and you can bring all your entities in a form that they all are within Europe. The reason government has given this opportunity, the reason being, if anything goes wrong, then European entity will be termed as non-compliant and they will be penalized. So right from the scope, collection, processing, and data subject rights, the process, how you can transfer data. Now there are various articles in GDPR which speaks about supervisory authority, monitoring of supervisory authority, establishment of supervisory authority, then penalties, on what basis you will be penalized. Like there are two sections, major and minor. 2% is of annual turnover, and 10 million euros, it comes under minor penalty, and 4% of annual turnover or 20 million euros comes under major. Now there are certain articles which says like these articles come under this penalty, this article comes under this penalty. And now it is not a case where if a article comes under major penalty, then directly data protection authority will go and penalize them for 4% of annual turnover or 20 million euros. No, they will look after all the evidences they have, in what ways the data was processed, why the data breach has happened. They will hear organization's part. They will perform a valid investigation, and after all those investigation, they come to a conclusion. So now this has created lot of reasons which has made an organization to look in terms of privacy regulation and privacy compliance. As we have understood, like we know that GDPR and CCPA and LGPD and many upcoming regulations will have lot of requirements for an organization to be compliant with them. So how does what is the role of privacy professional into this? Okay, so how they can help an organization, what an organization can do with a privacy professional when they have with them, and what is the importance or role of privacy professional in all of this. So now if you know that this regulation is not very common and everyone knows about it. So as we had like information security ISO 27001, then PCI DSS, all this came into picture, and it was like SOX compliance in 2002 it came, and for SOX compliance everyone was running behind SOX expert and legal experts and advocates and all. But this privacy regulations or GDPR or CCPA, it's not that it's only for advocate, it's not that it's only for legal background individual. It doesn't have any prerequisite for it. So any individual, as long as they have a knowledge about how GDPR works and how it is, so they can go ahead and further their career into this. And in today's world, organization need huge amount of privacy professionals. Demand is very huge and supply is next to negligible, if I say. Because yeah, I would like if I give my example, like when I started 3 years back, just to connect with this perspective, in 2018 this GDPR came up, and prior to that there were no such kind of urgency for hiring of privacy professional and major roles of privacy professionals. After GDPR, it has created a boom. And when I quit my job in IBM and I started working as freelance, I was not sure how it will be. But if you believe me, that in today I have lots of clients across Europe and in US. Everyone doesn't have business of millions and billions of dollars, so they want small service provider. They want freelance consultant who is expert into this. How you can prove them like you have knowledge into it. Okay, so see, I cannot go and tell each and every individual, okay, I'm a GDPR expert, GDPR expert. They are not going to sit an interview. First impression will go with the certifications, with the level of knowledge. Certifications prove that you have so and so knowledge. That opens door at least for you. And after that, you have to go and get your clients. So as far as I'm working, there is huge opportunity. There are small clients mainly who are targeting freelance consultants and all. And if you see major IT companies, they are looking for privacy professionals, but they don't have any. Even if you see in India, I guess we hardly have CIPP certified or CIPM certified kind of thing, which are the major certifications in terms of privacy. So now the role of privacy professional is very huge. Privacy being the need of the in today's world, every organization, as long as they want to do business, they want to do business globally, they have to comply with it. The reason being, all the regions are coming with their own privacy framework. If you see in Asia, you might be aware that we have APEC privacy framework. And if you go and see in China, they have some MPLS or MLPS kind of framework, which says that all the Chinese nationals' data should be within China. So India has drafted its personal data protection bill. It's in a draft state. Debates and discussions are still in process, and we are hopeful that we'll be getting that bill in a year or two at least. So every company is coming up with every country is coming up with their own privacy regulation. So now, where does privacy role fits in? So we all can imagine that if an organization wants to comply with n number of for today we have CCPA, GDPR, LGPD, the major ones, which creates a lot of liabilities on organizations to be in compliance with privacy regulations. Now going forward, it's not that regulations will be coming down, it's going on increasing day by day. So definitely organizations requirement and compliance will also be increasing day by day. So where does privacy professional fits in? If there are organizations who are now have started having separate privacy teams. Like earlier we had information security team, compliance team was separate, then now it has audit team was separate. Now we are having information privacy team as separate team and separate entity in an organization, and there are certain rules which have been defined through laws, okay, like GDPR. So main role of privacy professionals, if you would like to, if I would like to explain as listed down here, like what are the privacy obligations of the organization, who will know about it? A chief executive officer will definitely not know. Information security professional, he may know about some part if he had gone through GDPR regulation. But in today's world, if you and I have to believe that we all know the overview about GDPR, but that is not sufficient for GDPR compliance and for guiding our organization's business into GDPR compliance path. So we need in-depth knowledge. We need privacy professionals who have in-depth knowledge what GDPR exactly says, and some of the specific roles of GDPR would be like, what are the obligations of my organization? Like GDPR is there, okay. So is my organization under the scope of GDPR? Yes or no? You have to identify. You will only be able to identify as long as you know about GDPR. Then if yes, then what are the risks and what kind of regulations of GDPR falls under me? What all articles falls under me? What all things, what all categories of my business comes under GDPR? You have to identify the scope of your program. Once you have identified the scope, definitely you will come to know, okay, what level of compliance activities I need, how much work force I would need for this, and what kind of man hours I need, what kind of individuals I need. Then definitely privacy professionals come into picture, because they will define the privacy program, they will define the privacy strategy. And definitely if you don't have a privacy team who can guide your organization's business towards privacy compliance, then in today's world it's very difficult for an organization to survive. The reason being, if you are into a privacy non-compliance, the penalties are very high, and definitely penalties can be calculated on a paper. You can be assured that okay, maximum it will be 4% or 20 million euros, which is very huge. Even though if someone wants to calculate, definitely you can calculate, but there are some intangible things like consumer trust, loss of business. You can't calculate that. There might be a case wherein a small company who might just go bankrupt because of this penalty, no one will be coming to them, right? So and if big organizations are there, like if you go and do a Google search about Google data breach itself on Google, so you will come to know that Google has been fined multiple times in last 2 to 3 years under various sections of GDPR. It's not that GDPR is a framework, okay, you go ahead and just apply it. No, you have to understand GDPR in detail, or any privacy regulation, regardless it's GDPR, CCPA and LGPD. You have to understand in detail what all things it says, and what all things, suppose there are certain things which is being spoken in GDPR. So is it applicable to my organization? Is it applicable to my business? Am I falling under the GDPR scope? If yes, then what are the risks, what level I am falling under, and what kind of compliance activities I need to perform? All these things can be performed only if an individual have an GDPR knowledge and they are well aware about GDPR, CCPA, LGPD knowledge or regulation, and then they can guide their organization into it. Now, to make it very much formal, now if you see specific article 37 of GDPR, it specifically states that you need to have a data protection officer, a designated data protection officer within EU. Okay. Now, the reason being, an individual has to have an ombudsman or a person whom they can reach out to with their query. Okay. So data protection officer has been mandatorized GDPR, under GDPR, and it's not only under GDPR. If you study different laws, there are different laws. If you see, CCPA says the same thing. CIPPE, which is the Privacy or Electronic Documentation Act of Canada, Personal Information Privacy Electronic Documentation Act, South Korea's Data Protection Act. Everyone has mandatorized DPO, but again, it comes under certain conditions. Like if you are processing this many categories of data, then you definitely need this. If you are coming under this category of processing this category of business, this level of business, then you need DPO. In which case you need DPO, in which case you don't need DPO. So all these things can only be realized and can only be put in place if an individual has a knowledge on GDPR or a privacy regulation. I am quoting GDPR every time. The reason being, that is the one which is very much in implementation, and it's very much in scope. Apart from that, LGPD has recently came in, and CCPA is tumbling upon here and there every time they are revising it and all those things. So we are talking about mainly GDPR. So now if you see with the evolvement of technology, different ways of using data, way of doing business, it's totally online, internet based, more at risk, and more chances of data breach, and would say like individuals and the hackers both have become very much smart nowadays. Now that's the reason, and regulate each and every regulation is targeting about importance of privacy, knowledge, and the privacy importance an individual should place upon. So because of this data privacy concerns, changing regulatory environments, now social media is into place, people are using into it, people are sharing information. If you see, Google has been penalized, Facebook has been penalized, British Airways, you have Snapchat, you have Instagram, subsidiary of Facebook, you have Marriott hotel chain. So all these big organizations which have abundance of data with them have been penalized and are under the breach of GDPR. So we all can imagine that if such a huge organization, it doesn't set precedence that if you are a huge organization, you will be in compliance because you have resources or not. It has to be a perfect timing. The implement and has to understand the business model and where it falls under the GDPR. So all these things, privacy concerns, regulatory environments, then personal data being shared on social media, uses of different technologies, all those things add upon the role of privacy professional, privacy concerns, and that's what make privacy professional very important. So now how can organization reach to that privacy compliance? What is the route for organization? So the first and foremost step in organization is to realize that they are giving importance to their customers data first of all, and very normal way I would say they love their business, because if they want to keep up and running their business, then definitely they have to be in compliance with any privacy regulation. If not, then they will be penalized badly, consumer trust will be breached, business loss will be there, and there are chances that business can abruptly shut down, or they will have a very adverse impact on it. So definitely they have to look for a route to compliance, and I feel this does not start from bottom to top, it starts from top to bottom. Senior management has to realize what importance they want to place on their business model in terms of privacy regulatory compliance. So for this, first and foremost, and senior management has to understand their business model and their requirement of privacy compliance. Second step would be to how to reach that level. Definitely you need an expert to guide you to go through compliance and all those stuff. So definitely you will need a privacy professional for this. This where brings, again I'll come to a place where brings privacy professional into core picture and the center stage. In today's world, as cyber security is, as similarly we have very hot demand of privacy professional, because they are the only one who has expert knowledge on privacy compliance regulations, and these regulations are going on increasing day by day, and in next 5 years, as far as I see, there will be two major fields, which is cyber security and privacy. So you have to hire a privacy professional in order to guide your organization's business into privacy regulatory compliance way. So how does this work? First of all, senior management should be directly involved and must actively participate. The reason being, if a privacy professional is hired, and if he just designs a framework, and if he goes with two different teams, and if he starts doing activities, but you know, it's a human tendency that until and unless we are not enforced, or we are not abide by something, we don't that much importance on those activities. So definitely it has to come from senior management. They have to be involved, and they have to take that privacy into the organization deeper, and they have to make this privacy as an important aspect of their business model. This can be through training and awareness, highlighting their privacy team, training individual employees, keeping more focus on what importance they give to their privacy, whom they can reach out, who are the privacy professional in your organization. Then each and every department should be asked to take suggestions or guidance, or go through privacy teams channel, understand whatever activities they are performing are in compliance with this or not. For example, if database team is there, they have access to certain data, so definitely database team has to understand some portion of GDPR. And privacy professionals can also work with different teams, sitting with them, data retention or data deletion period, what it should be, how long data should be retained, how long data should be deleted. So a normal person can't go and just say, okay, we should delete data. If he has or she has knowledge, then only he can guide an organization for drafting data retention and deletion policy, data subject access request processes if you have. So if an organization has privacy officers or privacy professionals, they will be in a better way or in a better position to be in compliance with GDPR than an organization which doesn't have it. So now this has been regularized, and as I have told earlier that it has been formally regularized through GDPR, through CCPA, South Korean Data Protection Act, and PIPDA, Personal Information Privacy Electronic Data Documentation Act of Canada, and many other laws and regulations that you need to have a data protection officer within your organization. Apart from this, the importance or the, I would say, apart from regularizing or formalizing the importance of privacy professional in an organization, GDPR has also done a very great job in increasing the importance of that privacy professional within an organization. If you go ahead and reading GDPR regulation, it says that a data protection officer or a chief privacy officer, whatever abbreviation designation you give, should always be reporting to a senior management, and senior management comes mostly with C suits like chief executive officer, vice president, chief technology officer. So it has to directly report to senior management. So in this way, these regulations have created environment which I would say has created a boom of opportunities for privacy professional, not only in terms of getting a job or getting opportunities, but also importance of that job. You have to report to senior management, and privacy professionals are the one who can guide an organization towards privacy compliance. Definitely every organization has legal team, but there are certain technical aspects as well involved into this technical aspect, like data retention and deletion, rule creation for that, what tools do we use. There are certain terms used as pseudonymization, then anonymization. So those are technological terms, and encryption, then cryptography. Definitely some are common terms and some are not. So a person with in-depth knowledge of GDPR will be able to help. A person with an advocate or a legal team with GDPR knowledge will definitely be able to help in terms of defining policies. But the implementation of those policies on a technical front or on day-to-day basis is part of privacy professionals' job. So an organization who wants to go towards the route of privacy compliance has to identify their importance from senior management. It goes from top to bottom. Senior management should identify about its importance and requirement of privacy regulation. They should hire privacy professional. Privacy professional should be given an authority. They should be made an independent data protection officer or chief privacy officer who is reporting to senior management. Some basic steps. So based on my understanding and some of the articles which I have read, I have fetched out some of the important steps which has to be integrated in any governance model, because the governance has to start from top. So first step would be to involve senior leadership, involve stakeholders, develop internal partnership. I mean, a privacy of team is not working in isolation. It has to be the most involved team in today's organization, because each and every team and each and every activity being performed in organization should be aligned with the objective, vision and mission of that organization. So suppose I would like to give an example of marketing team of an organization. So they were doing marketing before 2018, 16 or 17, whatever it was. So that was totally different. And after 2018, it is totally different. Marketing, it can be a way that either you build an partnership between different teams, that before any activity you have to understand regulatory compliance in terms of privacy from the privacy team, or else from each and every team a person should be trained in terms of their operation. Suppose a marketing team person can be trained what all activities or what all regulations regulatory requirement falls under marketing team, he should be trained on it. If not, then marketing team should be asked to take suggestions from privacy team. Okay, we are using this kind of data for this promotional offer, so are we following the right person or not, right procedure or not to follow up the employee, because there are certain clauses in GDPR which says that you can't have information from third party and you can reach out to that customer directly, because that information was given to third party and you have acquired that information, so it doesn't goes that way. So you have to have a clear and crisp knowledge of privacy, and each and even everyone will agree that none of all the it's not a possible thing that everyone in the organization and all the teams in the organization will have privacy knowledge. There should be certain individuals. There might be a possibility that every individual or every single individual in a single team can be trained to perform his team's activity. And if certain big things comes up or complex things comes up, then they have to refer to privacy team. So that develops a kind of internal partnership and gives a kind of importance to privacy team. Then you have to communicate regularly, then you have to be collaborating and kind of create an environment in an organization that every thing has to go through privacy team, because they are the experts who can guide you. Why? Because this is not a normal thing if you come under non-compliance of privacy regulations, and there are multiple privacy regulations. If I say three comprehensive: GDPR, CCPA, and LGPD. And if you know about GDPR, you are in a best position to understand CCPA and LGPD as well. If I would say, the reason being, there is, I would not say 80 to 90%, but yeah, 65 to 70% overlapping is there in both those regulations. And LGPD, I would say, is, I guess, 70% based on GDPR, and CCPA is around 65 to 70%. And now they are revising some of the parts. We'll have to see what all revisions comes in. But if you are a GDPR expert, if you know about one privacy regulation and we have been working on it, then it doesn't take time for you to understand CCPA or LGPD. It's just other regulatory text for you. So this makes an organization to go and hire a privacy professional in order to continue their journey for privacy compliance. So now I have already explained you what is privacy, why we need privacy in today's, or what is the importance, why organizations are running behind it, and what is the importance we are keeping, why they are keeping that importance, what kind of depth we have in GDPR. So we have completed the presentation part over here. So I would just like to explain you the benefits. InfosecTrain is offering a course, a European data protection, and it's a certified instructor-led training. And so what InfosecTrain has done, they have drafted their course. In this course, they will be trained by a certified person who is CIPP certified. Then if you see, there are many other institutes who might be offering the course. I'm not sure. I haven't come across any time soon. So they are offering mainly, they are teaching you about GDPR, what it says, overview kind of thing. But what InfosecTrain is going to do, how it differs from other is, there is a regulatory text of GDPR which contains of 99 articles and 11 chapters. So InfosecTrain will be training you article by article and chapter by chapter, which makes you understand what each and every article says, how you can be in compliance with that article, how you can perform your day-to-day operational activities for your organization, and that gets you ready for day-to-day operation, to perform your day-to-day operations, like what are the data subject rights of under GDPR. So after the completion of course, you will be very much expert about the GDPR, and specific questions like what are the data subject rights, how can we comply with them, what GDPR says in terms of data retention and deletion, where we should perform data protection impact assessment, where we should not, and what kind of policies and procedures of clauses we have in place in order to transfer our data from one country to another country in order to be in compliance with that. How can we avoid compliance, non-compliance issues? How can we avoid penalties and all? So that gets you ready in terms of GDPR regulation, how to perform your activity in day-to-day environment. And this training will give you some examples on the real-time case studies. We'll be matching with this, like suppose an organization was breached because of so and an organization faced non-compliance issue and it was penalized for so and so reason. So why it was penalized and which clause was missed and how important was that clause, why they missed it, what they overlooked it. So those kind of real-time examples and case studies will be more helpful to understand your GDPR compliance, and definitely will help you and guide you how you can prepare for your CIPPE exam. It's we are not an authorized partner of IIPP, to be very much clear, but we have drafted the course which consists of all the GDPR requirements, 99 articles, 11 chapters, different guidelines from different organizations of European government. If you say European Data Protection Board, and also there are various guidelines as well, which will be constrained during the training and will explain you in specific details like how you can be in compliance with cookie thing, how you can be in compliance with data subject, data deletion, data consent, data collection. So there are a lot of things, and how you can prepare for your CIPP exam. So this will be a weekend batch. I guess the details about the timings and all will be in the next slide. These are purely weekend batches, and this is definitely cost effective as compared to IAPP training or other institutions who are charging more than lakhs. And so for cost details and all those things, you can reach out to InfosecTrain. And the details about the course or the dates are like, it's a 4 hours per day session in weekend. I guess Saturdays and Sundays it is, and it's a 4-day session, day evening 7 to 11 p.m. It will be of 32 hours, in which you will be taught about GDPR regulation spread across 11 chapters. Then how you can apply those articles in your day-to-day life with real-time examples, and guidance on how you can prepare and what all materials or details you can use, informations you can use to prepare for CIPP exam. So this training is of 32 hours, Saturdays and Sundays, starting 17th October and till 8th of November every weekend, 7 to 11 for 4 hours. So this is the final slide where you have the contact details of the InfosecTrain, where you can contact them and reach the schedule. And if you have any further queries, definitely you can reach out to InfosecTrain, and they will help you out on entirety of cost, courses we cover, how are we helping you in CIPP, how are we helping you in GDPR compliance training, how are we helping you in preparing for your CIPP exam. So that's it from my end, guys. Thanks for your time. Have a great day. Bye bye.